Thank you very much. Thanks, Madam Vice President, to be here in committee, and I'm also looking forward to our exchanges on the annual competition policy report. In that particular context, let's say there's of course a lot to say. In my first set of questions, I would go a bit more into detail on the issues of merger control. You mentioned the Illumnia case, and I very much welcome your decision of 2 days ago to prohibit the acquisition of GRAIL, precisely for the reasons that you have mentioned, that this is a growing market that would be basically destroyed from the outset. We have, of course, here the situation that they are looking at 2 American companies that as such is not a problem, yet a US court has approved the merger in the week before. So the FTC and the Commission are basically running in parallel investigations. So I'm therefore wondering whether you could elaborate on the extent to which you have exchanges with the Federal Trade Commission, to which extent these efforts are coordinated, and to which extent the US procedures have influence on our decision here in Europe. Second, more generally, you also mentioned indeed the General Court's judgment of 13 July approving the Article 22 approach of the Commission, which, let's say, the law expert in me said came to a little bit of a surprise, but nevertheless very much welcome, of course, as it is the opening without changing the merger regulation to deal with killer acquisitions. Do you have a knowledge whether the judgment is to be appealed and the European Court of Justice will have to have a last say on the matter? You quickly mentioned the merger control regulation. There is a need to update it, in particular when it comes to killer acquisitions. Article 22 is a somewhat working solution, but the merger control regulation, in my eyes, needs updating, just as the 1 year younger procedure regulation that you have mentioned before. So are there any plans of DG Comp to revise merger control regulation in order to update it? And last question in that context, one of the innovative elements that the DMA has introduced was a general clause on structural remedies for violations of DMA rules. And as you have also confirmed in multiple interviews, it includes the possibility to break up companies. Is it therefore also the intention of the Commission to include more structural remedies in the revision of the enforcement of the EU competition law rules and with even more precise and clear legal basis for actually adopting the breakup of companies? Thank you.
Well, thank you very much, and thank you also for welcoming the prohibition. It's in many ways a first. It's only the 10th prohibition within 10 years. It's the first prohibition on purely vertical grounds. Very often there would be conglomerate concerns as well. So it is a really exceptional situation. It's also exceptional in that the merger was completed almost a year ago. So the parties, they did not respect the rules, the standstill obligation, which of course has created quite a problem for themselves. Of course, we immediately imposed on them intermediate measures, holding things apart, which is, of course, even more relevant now because GRAIL will have to regain its independence. These are separate processes, both the investigation of the gun jumping, but also as to how actually to make sure that GRAIL gets its independence. We do exchange with the FTC whenever we have the relevant permissions from the companies in question. We do that. I think it serves the companies very well, and obviously it serves us very well that we have more colleagues to talk with. One of the reasons why it serves companies well is that if we find similar competition concerns, then maybe one remedy can solve concerns on both sides of the Atlantic. Sometimes that is not the case because market circumstances may be different. But if they're not different, then of course much easier for a company to solve 2 concerns that are similar with one go than having to do things in parallel. As you say, the administrative judge did not follow the plea to prohibit the acquisition. The FTC has immediately said in public that they will appeal this decision. I think they stand fully by what they asked for, which was a prohibition of the acquisition. We exchange, but obviously we are not influenced. We have our own investigation. We have talked with so many different parties in this case. We have gathered 1 million different documents because we have to defend our case in our own court system. So even though it's good to have colleagues that you can, have a dialogue with about how you see things, obviously it's our case, it's our investigation. We have gathered our facts, our theory of harm. We stand by that 100%. Yes, we think that the General Court judgment will be appealed. And that, of course, means that we will have a time where we will rely on the General Court, but where we do not have, the certainty that comes with a ECJ judgment. We do think that this approach to killer acquisition is a good approach because it allows us to review specific mergers where there is a specific concern. As you will know, we tested some years ago if we could find other ways, and the risk was that we would be flooded with all kinds of notifications of really small acquisitions that would take up a lot of resources, and we may not be able to find these specific acquisitions that would actually be really harmful to competition. I do think that the merger regulation works well. One of the reasons is that we do welcome and prefer structural remedies. Indeed, they are easier to deal with because they, once and for all, solve a competition matter. And of course, sometimes we have a monitoring trustee, but it's not like a behavioral commitment where you may have to monitor that for a very, very prolonged period of time. Also, as it is, we have in the antitrust regulatory framework the ability to ask for divestitures. So we do not need new rules in order to break up companies. What we cannot do is that we cannot break up a company if we do not have a really, really serious offense, because we, of course, are obliged by proportionality. So that should not be the case. And as I said, I do think that the merger regulation works really well.